Good morning and welcome to the Supreme Court of the United Kingdom. We are in the second day of an appeal by Balhousie Holdings Limited against Her Majesty's Commissioners of Revenue and Customs, and we are hearing the submission of the respondents, the Revenue and Customs, and I invite Mr. Beale to continue his submissions.
My lords, my lady, the cliffhanger element of yesterday involved the 2011 order and the changes it made to Part 2 of Schedule 10. Why were those changes made? That requires us to perhaps look at the context in which the changes were made. Now, as your lordships and your ladyship will recall from yesterday, land has the complicating feature that it can be exempt, standard rated for commercial property, or zero rated for some commercial property with a relevant purpose. That necessarily had an implication for the capital goods scheme and its treatment of land as a capital item. The capital goods scheme does not cover exempt supplies of land because there is no relevant output tax which needs to be adjusted by the recipient of an exempt supply. Similarly, the capital goods scheme cannot cover zero rated supplies of land. Again, for the same reason, there's no output tax charged to which an input tax adjustment would be needed. Now, what that meant was that you could, in principle, have a zero rated land transaction in circumstances where the conditions for zero rating changed or were no longer met within an adjustment period, which didn't, on its face, fall within the capital goods scheme, and for which, therefore, no adjustment could be applied. Notwithstanding that in comparable circumstances for standard rated commercial property, a relevant change in use or disposal of the asset would lead to an adjustment in the input tax recoverable. Now, in order to put flesh on that particular bone, please could I invite you to turn to page 1108 of the bundle and have a brief look at the capital goods scheme. At page 1108, we see that Regulation 112, subparagraph 2, says any reference in this part to a capital item shall be construed as a reference to a capital item to which this part applies, being an item which a person uses in the course or furtherance of a business. Turning over leaf, page 1109, 113, Regulation 113, subparagraph 1 states, the capital items to which this part applies are any of the items specified in paragraph 2, on or relation to which the owner incurs VAT bearing capital expenditure of a type specified in paragraph 3. So you don't get within the capital goods scheme unless there's an initial amount of input tax that you have to adjust over a relevant period. To confirm, Regulation 1132A covers land and Regulation 1132B covers a building or part of a building. Relevant expenditure can take two forms. Under 3A Roman 1, it can be expenditure incurred in the acquisition of the building. Under 3B Roman 2, it can be for construction, including where appropriate manufacture. So what that leads to is a position here where the construction of the building was undertaken by Fiscali in circumstances where it incurred input tax on that construction. It would have been a capital item for Fiscali, but of course we know that Fiscali disposed of the good to BCL by way of a zero-rated supply. That zero-rated supply to BCL would, in principle, have been an acquisition of a capital item, but for the fact that no VAT-bearing expenditure was incurred on it, because there was no output tax charge by Fiscali to BCL. So whilst Fiscali incurred VAT-bearing expenditure, BCL didn't. And what that meant is you ended up with a zero-rated acquisition of a capital asset to which the capital goods scheme was inapplicable. Now, the fact that, for example, an exempt acquisition of a capital item would fall outside the capital goods scheme is not a problem, because, of course, there's no question of any associated input tax recovery. In contrast, if you have a zero-rated acquisition of commercial property, which in principle is capable of competing in the market with standard rated commercial property, you do have a potential problem, because the effect of zero rating, other things being equal, would be to mean that there was no output tax charged. Earlier input tax recovery continued unabated, could potentially pose a threat to the integrity of a system based on a series of transactions in which VAT is in principle to be passed on through links in the chain. Now, if one has a position whereby the capital good in question is acquired on a zero rating basis, and the capital good scheme doesn't allow for its adjustment, that could lead to a situation in which the person who has acquired a zero rated capital item is able to change its use immediately after acquisition, having paid no output tax as an input tax on the cost of acquiring the building, and then changes its use to a fully taxable use, for example, deriving thereby a competitive advantage over other commercial property transactions in which the transaction is standard rated throughout. So this gives rise to a potential disparity in the treatment of a capital item. And it was no doubt with this in mind that the position prior to the 2011 order was the 2008 order, which sought to address the risk of a change of use of a zero rated building during a 10-year adjustment period. We suggest no coincidence that the 10-year adjustment period reflects the mechanism for adjustment that one finds in the capital goods scheme itself. Turning to that adjustment process, if I may, we can see at page 1111 of the bundle, Regulation 114, which puts in place a structure essentially where over a 10-year period, the initial deduction that has been obtained on the acquisition of a capital item is subject to a series of successive intervals in which an appropriate adjustment may have to be made if the circumstances set out in Regulation 115 are met, which deals with the method of adjustment. And so one sees at page 1113, Regulation 1151.
I wonder, Mr. Beale, if I should ask my colleague Lady Arden to mute her laptop.
Apologies, I hadn't realised it was on.
We're hearing her typing. Thank you very much.
Sorry.
Regulation 1151 envisages a situation in which there's an increased use of the relevant capital item for taxable purposes. Obviously, the initial deduction that's given in most CGS cases, most capital goods scheme cases, will be derived by either the taxpayer is fully taxable, in which case it recovers 100% of the input tax it occurs on the relevant acquisition, assuming it's a taxable acquisition, which it has to be to get into the scheme. Or it's subject to either its partial exemption special method or the standard method for applying if it's a partially exempt trader. The position will be that if there is an increase, for example, in the taxable supplies by a taxable trader over a 10-year period, for each successive one-year interval over a 10-year period, it can increase the amount of input tax it has recovered for that year, compared to the initial deduction it conducted originally. Conversely, under Regulation 1152, if there's a decrease in the level of taxable activity, that would require a respective adjustment of the initial adjustment that was given, so that the taxpayer reflects the increased non-recoverable use of the asset in question. So you have this 10-year sliding scale with an adjustment process to reflect the changing use of the actual asset for VAT purposes, consistent with the overall VAT scheme. If, for example, you recover input tax of £100 in year one, but in year 5 you switch to a wholly exempt activity for the use of that building, so you switch from making standard rated supplies, say, to hiving off an insurance arm, that the insurance arm of a business uses that building exclusively for supplies of insurance, then you would need to make an adjustment that reflected the exempt use going forward of that building because it was making exempt supplies of insurance. Now that can lead to a situation under regulation 3A and 3B of, subparagraphs 3A and 3B of regulation 115, where somebody has to account for tax back to the commissioners. So if your subsequent use of the relevant capital asset leads to an increase in non-recoverable VAT, that may lead to the taxpayer having to pay VAT back to the commissioners, and that's expressly contemplated in regulation 115 subparagraph 3B. Now, one also sees in regulation 115 subparagraph 3 and 3ZA that, in contrast to distinction to simply changing the proportion of use of the capital asset, there is also provision made for the disposal of the whole interest in the capital item. And so subparagraph 3 says, where during an interval other than the last interval, the owner supplies the whole or part of his interest in the capital item, or is deemed to do so, then paragraph 3ZA applies. Now, 3ZA then says, if the supply of the capital item referred to in paragraph 3 is a taxable supply, the owner shall be treated as using the whole of the capital item for each of the remaining complete intervals, wholly in making taxable supplies. Conversely, the parity of treatment is given if it's an exempt supply. So what that means is after 5 years, if the guillotine comes down and the whole interest in the capital item is disposed of, then you take the treatment, the tax treatment of that disposal as being the answer to the adjustment for input tax purposes for the remaining period. So if there's an entire disposal of a capital item on an exempt basis at year 5, having had full input tax recovery at the start, there will be a charge to recover 50% of the relevant input tax because it's treated as reflecting an exempt use of that capital item for the remaining periods. So that is the sliding scale system that was introduced under the capital goods scheme. That was not a scheme that was capable of being applied to zero-rated transactions. And in principle, for the reasons I've indicated, that is capable of giving rise to disparate treatment between standard-rated commercial property transactions and zero-rated property transactions. And the UK Parliament, no doubt cognizant of the criticism it had received in the infraction proceedings for overly favourable treatment of commercial property transactions, in 2008 introduced in Schedule 10 the change of use regime that preceded the relevant paragraphs that we're dealing with. That change of use scheme sought to deal with the fact that it was possible to have a zero-rated transaction where the zero-rated conditions did not continue to be maintained throughout the relevant 10-year period. And what the previous provisions envisaged was that if there was a change of use coupled with a grant of any interest in the relevant property, then that sufficed to bring about a charge to tax on a self-supply basis. So that required not simply a change of use, but also a supply of an interest in the capital item. What the 2011 changes did was to divorce the need for the matter simply to be determined by reference to change of use. As I indicated yesterday, it avowedly brought in, the changes avowedly brought in the concept of a disposal of the entire interest in the property as being sufficient as one of the conditions for a change in the VAT treatment to be applied. Now, one of the problems, of course, that had arisen with the 2008 approach was that it might be possible for somebody like a charity to have a capital item that is acquired for a relevant charitable purpose, and which is therefore properly zero rated. The charity might dispose entirely of that building and have no more to do with it. And the purchaser of that building might then choose to use it not for a relevant charitable purpose. But the charity would have no way of knowing, having disposed of its interest in the property, no way of knowing or controlling the use to which the subsequent purchaser would put the building. So a charity might sell it on one basis, saying, well, the purchaser's assured me it's going to carry on using this for a relevant charitable purpose, and I believe him. And then find itself 2 years down the line with a change of heart from the purchaser, bringing into play the self-supply charge in circumstances where the charity had not been able to negotiate in advance for that self-supply charge to be split between them, or indeed passed on to the purchaser. So it put charities in an invidious position. The other difficulty with having a regime that's simply based on change of use is that it's very difficult to control and monitor when the person who is liable to the self-supply charge is not master of its own destiny. So in circumstances where the possessor and owner of a building has disposed of ownership of that building and is no longer in control of it, it is entirely possible that there could be an underlying change in use without the disponer, having anything to do with it or knowing much about it. Now, conversely, that also gives rise to the risk of avoidance, because one could end up in a situation where there was otherwise a disposal of the entire asset, the scope for a change of use, and real practical difficulties associated with knowing at what point the change of use applies. And indeed, this practical difficulty is endemic, we suggest, in my learned friend's construction of the provisions, because it turns on the ability to monitor and supervise and apprehend when the relevant change of use or disposal of the entire good has taken place as a matter of construction of the lease and or the enforcement of the lease. And so one ends up in a position where, for example, it's perfectly possible that this particular lease could be determined for irritancy. That may be subject to court proceedings. We simply don't know at what point in advance the entire interest will fall into the category, on their case, of having been disposed of entirely. Conversely, the lease also provides, for example, for determination in the event of an insolvency. So one can imagine a situation in which there is a voluntary winding up of the person who has disposed of the property that's subject to a lease back in due course. That insolvency triggers the right to determination. The entire interest is then transferred. But of course, by then, we're seeking to enforce a tax liability on a self-supply basis against a company that is going through an insolvency procedure. And that, we respectfully suggest, are two practical examples that are likely to arise in practice, which make it very difficult for HMRC to be able to say with certainty at what point on the appellant's case the entire interest has in fact been disposed of. And it's also in circumstances where the actual ownership of the capital item no longer rests with the person against whom you can raise the tax. So you have a disparity between control and liability to the tax. And that's generally a bad thing in taxing purposes, because you're reliant on being able to ascertain what a third party's done in order to determine how you react to the specific taxpayer. Now,
Mr. Bill, that's all very interesting, and I can understand the revenue's concerns, and I can see the predicament which a charity might be in the circumstances which you describe. And a well-advised charity might wish in any relevant disposal to take a protective step, either by way of being informed or passing on or whatever, to protect itself. But at the moment, I can't see why your construction makes a charity any significantly less vulnerable to those sort of problems, or the revenue less troubled by those sort of uncertainties than the appellant's construction. It would help to have a concrete example of a case which, if you like, doesn't trigger subparagraph 2 on the appellant's construction, but does on yours, demonstrate there's a fundamental difference between the two in terms of dealing with those supposed difficulties.
Well, I mean, this case is in fact the paradigm of an example in circumstances where one is entirely dependent upon the terms of the lease entered into between Balhousie and Target in order to know, on their case, at what point the actual disposal of the interest takes place.
But well, I'm not quite sure why that's so, but even if it is,
if on your construction, there wouldn't be a disposal of the whole of the interest if the charity, or P in the statutory framework, granted a lease but retained what in England at any rate we call the freehold reversion. But why wouldn't then the protection of the grantor, P in that case, be equally dependent upon the terms of the lease?
Because the terms of the lease are entirely within the control and enforcement of the person granting the interest. If you dispose of ownership in the property, ultimately you are no longer in control of the use of the asset. Whereas if you grant a lesser interest in that asset, you can still control and enforce its use. In a much
many landlords with a relatively modest reversion, sufficient nonetheless to avoid triggering subparagraph 2, would say it was the tenant who had all the relevant control rather than them, depending on the terms of the lease.
Parliament has chosen to use disposal of ownership as a bright line test by which to assess whether or not control has been retained or not. What they seemingly didn't want to get into was arguments about change of use based on the actual terms of any lease or any subsequent use once you have assumed that there is a bright line change in ownership, which means that ultimately control no longer vests, for better or worse, in the person who derived the benefit of the zero rating. And it's simply for that reason. There's 2 points I probably should make in response to your lordship's point. Firstly, if the intention was to try and apply a similar regime to the CGS, the capital goods scheme, which my learned friend Mr. Thomas said yesterday was the case, then the logical consequence of that is applying regulation 1153ZA. The transaction that we see here amounts to the disposal of the capital item for the capital goods scheme. It was an exempt supply, and the capital goods scheme would produce a charge to tax in exactly the same way as we are saying paragraphs 35 to 37 do. So that's the first point. And the second point is the actual rationale for having this bright line test was Parliament simply set that as the test, and everyone knew where they stood. So it had the significant advantage of legal certainty. It means you don't have to pick over the bones of the terms of the lease or its enforcement, and therefore everyone knows where they stand. My lady had a question.
Yes, please. I too have real difficulty in understanding why we're going into this level of details about the capital scheme's adjustments. As I understood it, we were looking at capital scheme adjustments simply analogically to work out that in EU law, see, for instance, it's not the only case, Maidabel, the Court of Justice looks for substance over form, not at bright lines. And that was the point at issue. We weren't going into the particular regulations or how you did the adjustment. And it was being said, if you do it in relation to capital goods adjustments, why not in relation to sale and leaseback in this situation where effectively control remains with Balhousie? Moreover, if I may remind you, in the case of Maidabel, it was key that the lenders to Maidabel could not sell the property. So control in that instance remained with the party undertaking the financing. And the court looked at the substance over the form. But I don't understand from the appellant's argument that we need to go into the difficulties of adjustments or to understand the reasons why the capital scheme adjustments are framed as they are, or why use was taken as the criterion. We simply have to, as I understand it on their argument, take the view that Parliament has not accommodated the developments within EU law, which permit a more commercial and substantive view to be taken of concepts within that law, particularly for our purpose, the concept of disposal of the property, and look in the case of sale and leaseback specifically to the substance over form. That's as I understood the argument, and therefore, for the last 15 minutes, while I've been following it very closely, I have failed to see how it engages with the appellant's case.
It engages with the rationale, my lady, for the introduction of a similar scheme for adjustment to reflect use, because we are dealing with a capital item. The capital item is land. Land in this case isn't simply exempt or standard rate, it can be zero rated. As I indicated, the capital goods scheme doesn't apply to zero rated transactions. And so what Parliament introduced through Part 2 of Schedule 10 was a scheme, not the same as the capital goods scheme, but the bare bones of which function on the same basis and with the same rationale as the capital goods scheme. And so what Parliament was seeking to do was to reflect the fact that land held for a significant period of time, over 10 years, can change its use. The taxpayer can change the underlying transactions to which the building is put. Those transactions can move from being transactions that fall within the scope of something covered by the zero rating conferred in the first place to move outside that. So it could, for example, be the case that a taxpayer simply shuts down a residential care home, changes it into purely commercial property, and lets it going forward on that basis. Now, that would require an adjustment to the input tax that had been claimed at a prior stage. And so the way to deal with that Parliament has chosen is not to seek an adjustment to the initial recovery, but to impose a self-supply charge. And
yes, I understand the self-supply charge and why you do it, but we're not talking about shutting down a residential care home. We're talking about a situation in which, looking at it substantively, there is no change in use and control. It's the uninterrupted and permanent user that's talked about in Majesty. And that's the case, as I understood it, we had to engage with. But that's
my lady, prior to the changes introduced by the 2011 order, there would have been no change of use. There would have been a disposable of an interest, but the self-supply charge wouldn't have arisen. So the reason I preface this with saying we need to look at the reasons why the changes made by the 2011 order were made were so that I could emphasize that the 2011 order changed it from being a scheme based on change of use to include very specifically and deliberately a change that arose from the disposal of the entire interest in the property.
I understand that. It's very like your argument that if you've done a transaction another way, you might have saved that altogether, which is not a possible argument. I quite accept this is a transaction post-2011 and that we're looking at the new provisions.
Yes, and so looking at those new provisions, it's perhaps best if I turn immediately to them. They're at page 1064. We see it starts at paragraph 35 with one or more relevant zero-rated supplies being with the target, the focus of this particular set of provisions. So that's a subparagraph 1 of paragraph 35. Now, we then see a series of definitions that are important. We're dealing, of course, with a relevant zero-rated supply. What does that mean? Well, it means a grant or other supply which relates to a building. It's not dealing with dwellings, it's simply dealing with that subset of zero-rated transactions that relate to the first grant of a building for a relevant residential purpose, and of course the associated supplies in items 2 to 4 associated with it. So the sort of concurrent supplies of professional services and incorporated building materials would also be within it. But you have my submission from yesterday. It's very difficult to envisage an onward supply of building materials that have already been incorporated. So we then see that essentially this is must be looking at the first grant of a building that is intended for use solely for a relevant residential purpose. Let's confine it to that for present purposes, and which as a result of Group 5 of Schedule 8 is zero rated. Here, that was the case. What was the transaction that meets that description? Answer, the Fiscali to Balhousie transaction, which was a zero rated supply, first grant of a newly constructed building. We then move on and see that relevant premises means the building in relation to which a relevant zero rated supply has been made. Now, again, dealing solely with the facts before us, that must necessarily refer to the Huntley care home, because it's the Huntley care home that has been subject to the zero rated supply. I'm going to ignore the bungalows because everyone has. we then see that relevant period in relation to the relevant premises means 10 years beginning with the day on which the relevant premises are completed. Now, that then harks back to November 2012 and the date of practical completion of the care home. So just focusing solely on the definitions used in paragraph 35 for the moment and recognising the group treatment that's accorded under subparagraph 3, we're in a position where the relevant zero-rated supply is the first grant of a newly constructed building, namely the care home, and the intended use of that care home is for a relevant residential purpose. Paragraph 36 then says in subparagraph 1, paragraph 37 applies on each occasion during the relevant period when there is an increase in the proportion of the relevant premises, and as a result, the proportion of the relevant premises exceeds the maximum proportion of those premises, so falling at an earlier period. Now, it was described as cumbersome, but what that provision is designed to achieve is a situation in which you can have successive interests of a zero-rated transaction disposed of or dealt with, changed in their use can be changed over time. So it isn't an all or nothing provision. It's designed to deal with permutations in which use is changed for part, all or part of a building, and that use changes at various different stages over the 10-year period. So it's intended to capture a variety of different factual scenarios. Paragraph 36.2, I mean, in our case, of course, it's easier because there has been a disposal of the ownership of the property, which is binary. It's 100%. So at face value, we have a disposal of the property, which is 100% of the property. 36.2 then says the relevant premises fall within this paragraph if P has, since the beginning of the relevant period, disposed of P's entire interest in the relevant premises or part. Now, in context and by reference back to paragraph 35, that can only be, as I've defined it in paragraph 35, a disposal of P's entire interest in the Huntley care home. And that interest is the zero rating supply of ownership of the property. And so necessarily one needs to see, has ownership of the property been disposed of by P? Because otherwise it doesn't make sense by reference back to the definition of relevant zero-rated supply, nor would it relate back to relevant premises. Now, that construction, I'm leaving aside subparagraph 3 because it's clear that doesn't apply. That only applies disjunctively if you're not within paragraph 2. And there's no suggestion here that there's been a relevant change of use. So paragraph 3 can be ruled out from both sides' perspective. I can't rely on it and my learned friend doesn't advance. So we are in a position where 2 applies as a matter of principle, unless there's a reason to say that the focus on entire interest doesn't relate to the specific interest that's already been identified in paragraph 35, namely the relevant zero-rated supply, which in this case was the disposition of entire ownership in the Huntley care home.
I wonder if I could interrupt you, please,
Of
Mr.
course, sorry, I was looking down with my glasses off.
That's okay. You equate the disposal in 36.2 with the relevant supply, but looking at the wording of 36.2, it talks about the entire interest in the relevant premises, and the relevant premises are defined in 35.2 as being the building. Prima facie, looking at the statutory wording, if the initial transfer of the major interest in land were a long lease, and thereafter the recipient of the long lease acquired the landlord's interest, the ownership of the property, would not 36.2 require the disposal of the entire interest to include both the lease and the landlord's interest? And if the answer to that question is negative, why?
So the answer is that you wouldn't take into account a separate transaction involving the landlord's reversionary interest if the relevant zero-rated supply is a supply of a long lease, which is a grant of a major interest in land, which is a supply of goods. So if the relevant zero-rated,
where in the statutory wording do we see that?
well, my lord, because the focus back from 36.2 is on the relevant premises falling within, having been disposed. The relevant premises fall within this paragraph if, during the relevant period, P has disposed of his entire interest in the relevant premises. Now, relevant premises means the building in relation to which a relevant zero-rated supply has been made. So one's not dealing with a building as a physical construct. One's dealing with the concept of a building tied in with a relevant zero-rated supply. And so when one focuses not on a property-based construction of this, but as a fiscal statute with VAT, with its emphasis on inputs and outputs and supplies rather than the underlying physical goods that are the issue here, one sees that the focus of the statutory draftsman is very much on what is the relevant zero-rated supply that has taken place.
But if that had been the case, why didn't they refer to the relevant premises as the interest in land in respect of which the zero-rated supply had been made? I mean, the focus of the statutory wording is clearly on the physical building itself.
Well, my lord, the definition of relevant premises says means the building or part of the building in relation to which a relevant zero-rated supply has been made. So that draws the construction of the statute necessarily away from a consideration of the physical premises to a consideration of the interest in land, which is a sale of goods, which in this case, which has been supplied. So if one has, I mean, this also, of course, has to apply to, this has to apply not simply to the grant of the entire interest in the property, i.e. ownership. It also has to apply, as my lords indicated, to major interests, which would include a long lease. If a long lease has been granted and the entirety of that long lease has been transferred to a third party, then that would be a disposal of the relevant premises, regardless of who occupies on a reversionary basis the building in question.
I have your submission, but I think Lord Briggs would like to follow up the question.
My lord, yes.
Can I follow up Lord Hodges' example, the one I was going to use a little further? So you would assume that P acquires a qualifying major interest lease of the premises, must be more than 10 years, I think, for the relevant term, and then acquires the freehold. The acquisition of the freehold would presumably be exempt, because it wouldn't be a first grant.
Well, it depends on the facts. I mean, I think in principle, that must be right.
Yes. Well, let's assume that's right for present purposes. Under English law, and certainly, and I assume under Scottish law, the effect of acquiring the freehold by the lessee would be to merge the lease into the freehold, so that the only interest capable of being recognised in the lessee, the original lessee after that, would be the non-included freehold owner.
Well,
now, at the moment, you wouldn't, I think, suggest that that was a disposal of the lease.
Well, if one is merging, there wouldn't be an onward transfer of the lease to any third.
No. For any number of 150 good reasons, that wouldn't be caught by subparagraph 2.
Yes.
But then all anybody could look at thereafter to see whether subparagraph 2 was triggered would be to see whether the freeholder, the by then freeholder, disposed of his freehold, or disposed of the whole of his interest. In other words, conducted some disposal that wouldn't leave him anything left. I mean, that depends on which construction is right, I accept. But on no approach could it be a view about whether he had disposed of that which he had acquired under the original zero-rated transaction.
Well, my lord, if the subsequent transaction on those facts involves the disposal of, at the very least, the interest that was the relevant zero-rated supply, I imagine it's a 120-year lease, which has been granted. There's then, as a separate transaction, nothing to do with what we're looking at. There's an acquisition of the reversionary interest. If, on the facts, there has nonetheless been a subsequent supply of at least the 120-year interest, then the initial interest that was acquired has been disposed of.
Well, if the subsequent lease had different covenants than the original lease, because it would be a wholly new grant out of freehold, how would you work out whether it was at least as much as what had originally been inquired? Why isn't it just much simpler to ask whether once P has got the freehold, he's disposed of his entire interest?
Well, because, my lord, the focus is on the benefit of zero rating from the relevant zero rating transaction and whether or not the conditions for the grant of that zero rating have been maintained. So one needs to bring to bear not a very specific property law, real property law based focus on the underlying transaction. One needs to see, has the use of the building changed, or has the building that is covered by the relevant zero rated supply, has that supply changed in such a way that the original conditions for zero rating are no longer met? That's the statutory purpose behind this, is to cater for a situation in which either the underlying use or indeed the entire building that is the subject matter, or the entire property interest that is the subject matter of the original zero rated grant has gone. So one needs to construe the statute with that in mind. What did Parliament have in mind? It had in mind a situation in which there would be a charge to VAT, which effectively operated akin to the capital goods scheme to cap the benefit of zero rating if a relevant change in circumstances had taken place. And Parliament chose to define a relevant change in circumstances as being the disposal of the entire interest. One therefore needs to look at what the relevant entire interest is, and if the entire interest is a major interest in land, therefore a supply of goods, if that major interest in land is transferred, disposed of by the taxpayer, then that means that the original basis for zero rating is no longer maintained. Now that construction, I say, is reinforced when one considers paragraph 37.1, because that says, where this paragraph applies, P's interest, right or license in the relevant premises held immediately prior to the time when the increase occurred is treated as if it was supplied to P for the purposes of a business which P carries on. So one's focusing very much on the interest in the underlying zero rated transaction, and then we're focusing on that bit of that interest which is still retained. What that envisages is it's possible to have successive transfers out of the original zero rated transaction, so that you part, for example, with use of floors 1 to 3 on one basis and then floors 3 to 5 on another basis. You end up with a chunk of use of the building that needs to be dealt with at a subsequent successive interval during the 10-year period. And that supply is then taken to be a taxable supply, which is not zero rated. So again, the focus is not on what is the property treatment for real property purposes of the transaction. The question is, has the original zero rated transaction from which you drew benefit led to a situation where it's envisaged by the statutory draftsman that original zero rated supply will give you initially 10 years worth of use for that property. If over that 10-year period something changes, then that initial zero rated, the benefit of that initial zero rating isn't maintained and needs to be dealt with by an adjustment mechanism. That adjustment mechanism then envisages that there will be a self-supply charge to give effect to functionally what would have been achieved through the capital goods scheme. And in that way, it's capable of avoiding disparity of treatment and avoiding any concerns that commercial property transactions can take place, drawing the benefit of zero rating through avoidance measures. So this is in part designed to bring parity of treatment with the capital goods scheme. It's in part designed to deal with avoidance issues, as the upper tribunal rightly held and as the Court of Session endorsed. And there's been no separate appeal against those conclusions by either the upper tribunal or the Court of Session. So we do respectfully suggest that you necessarily have to construe paragraph 36 and the reference to entire interest, both by reference to how the mechanism for dealing with the taxation of that supply is then dealt with once it's been disposed of. So it's not treating it as a disposal of a property interest, which is purely a conveyancing matter. It's saying the disposal of the entire interest in the relevant premises gives rise to a supply for VAT purposes. So it must necessarily be treated as a supply of goods in this case, an onward supply of goods, and we need to look at what the onward supply of goods was. Here, the onward supply of goods was the disposition of ownership in the care home. And we say that's reinforced when relevant premises is expressly defined not by reference solely to the building, but it's by relation to a building in relation to which a relevant zero rating supply has been made. So one needs to identify what is the interest that has been conferred by the initial zero rated transaction. Have circumstances changed? If yes, has the interest that was conferred by that initial zero-rated grant been disposed of in its entirety? And sale and leaseback, I'm afraid, for better or worse, does not give rise to a situation in which you could say that the entire interest in the ownership has not been disposed of, because it necessarily follows from the fact that there is a sale of the entirety of the property and then a leaseback, that there has been a disposal of the entirety of the property, the entirety of the ownership. Now, different considerations apply with leasehold, but ultimately, in my submission, if one focuses on a long leasehold interest, then the same reasoning would apply. But the position is, if it had been a lease and leaseback, we would not be here, because it wouldn't be caught. Now, if I may, let me just finish my thought, if I may. That mirrors entirely the capital goods scheme treatment as well. So there's no disparity here with the capital goods scheme. My Lord Briggs had a question for me.
Yes, I hope I'm not fogging the discussion, but I asked your opponent about a hypothetical transfer of a 20% per annum beneficial interest in the property over a period of 5 years. Now, at what point would paragraph 37.1 be triggered? Would it be the last transfer, when he went from having 20% to nothing?
Part of the difficulty here, perhaps, is that the disposal of an undivided interest in property is treated as a supply of services, not as a supply of goods. But as a matter of principle, simply looking at paragraphs 35 to 37, that's by the way, that's paragraph 1, I think, of Schedule 4.
Yeah.
But for the purpose solely of looking at paragraphs 35 to 37, if you have the supply of successive interests in part of a property, then the disposal of the entire interest, one needs to focus on what did they get in the first transaction that was zero-rated. If it was complete ownership, then you wouldn't have disposal of the entire interest in that ownership until the last of all of the official conferrals were given.
Well, if that's right, then the interest right or license in the premises held immediately prior to that time, because that's when the increase would only be a 20% increase.
Yes, because you would,
which would seem, therefore, it would cut the self-supply down to only a 20% interest if you didn't aggregate the last transaction with the earlier ones, which would seem to be an awfully large scope, hole in the structure of the scheme.
Well, the alternative construction would be that when you disposed of it at that stage, if it was on the year 10 of a 10-year period, and you are effectively then accounting for 1/10 of your of the value, then that's in keeping with the purpose of the scheme, which is to provide a sliding scale of recovery, which would be right.
Well, suppose it all happened I mean, it doesn't matter whether it happens in year 10 or year 5. I was thinking of 5 transactions over 5 years. But you're saying that 37.1 would only impose a self-supply charge, in my example, on a 20% interest.
No, you would have an adjustment as at year 5 of the entire amount.
Even though, well, I'm not quite sure how that works from the construction of 37.1.
Well, because there wouldn't have been, one needs to look at it in terms of the proportion of the premises that's changed, and because you wouldn't have had a change of use and it would only be the entire disposal, that it would then be a binary figure as at year 5, right? You wouldn't, the successive intervals with successive use only really makes sense for change of use of different parts of a property over time. When you have a binary effect of there's a disposal of the entire interest at that point, that's when all of the interest tax falls in.
Very well. Thank you.
Now, I'm running a little short on time, but I think I've covered quite a lot of the points I wanted to cover. Now, I mean, in practical terms, what we are dealing with in paragraph 35 and 36 is almost inevitably going to be the first grant of a major interest in the building, which is intended for use in a relevant residential purpose. The items 2 to 4 of Group 5 don't matter because they will simply be subsumed within that first grant as a matter of practice. So that particular hair that was set running, I think, can be dealt with. The act of disposal that's referred to here is necessarily, in Scots law, transfer of a major interest is either going to be a lease exceeding 20 years or ownership. My learned junior will take you through the transactional documents that confirm that here there was the disposal of ownership in the course of the sale and leaseback. Now, it's true, of course, that BCL is now a lessee, but it's a lessee under a different transaction with a different taxable person making the supply. That lease is not zero rated, and its treatment for VAT purposes, therefore, is necessarily different from the treatment of the first sale. It's an exempt supply by target to BCL, not anything else. The fact that BCL remains in actual possession of the property throughout, which I apprehend that the court is troubled by the fact that there is uninterrupted use here. And under the scheme prior to amendment by Parliament, that would have been a complete answer to the self-supply. But Parliament, for better or worse, chose to use the words it adopted. It did so because it was a bright line test that it thought would be workable and practicable. And it chose to impose a charge to tax where there was a disposal of the entire interest of the relevant zero rating transaction that otherwise generated the benefit of zero rating over a 10-year period. And the mischief that was aimed at was the scope for that use or the underlying purposes to which the building was being put changing. Now, true it is, you can have a disposal of the ownership where the underlying use doesn't change, and this is one such case. But Parliament chose nonetheless to legislate on a bright line basis to exclude that category regardless of the position of use. And so when one is construing the relevant provisions, one needs to bear in mind that Parliament deliberately introduced paragraph 36(2) to meet a perceived mischief. And that perceived mischief was that once you have a disposal of the entire interest in the property, in the relevant zero rated transaction that's taken place, it's very difficult to monitor, supervise or control that particular use. And it's with respect no answer to say, well, we have the benefit of a lease and we can rely upon the terms of that lease and we will comply with them, because that would require the commissioners to be able to investigate the circumstances behind whether or not the lease was being enforced. Was it at some stage terminated? At what stage was it terminated? What if there are legal proceedings challenging termination, so that it's treated as terminated, but then that's reversed? All of these factors may well have prompted Parliament simply to say we prefer a bright line test. And as I've indicated, there was also the concern to avoid charities being in a position whereby they were suddenly faced with a self-supply charge after they'd got rid of their own buildings. Now, I do need to deal with responsibly with a couple of points. My learned friends referred to the Sargison case.
Could I just ask a question before you get there? On the question of mischief, is this a question of inference from the provisions? Or is there some document to which we should be referred?
Well, my lady, the various attempts below to refer to, shall I say, non-statutory materials didn't meet with favour. And so I haven't sought to replicate that process, given the findings from the FTT and the upper tribunal, that those materials weren't terribly helpful.
Okay, the lead-on question is, what is the impact of EU law here? Could you just help me on this? The position is that we're looking at, of course, a Westminster statute. But if the underlying concept is one of EU VAT law, in which we're bound to apply the principles of EU law, then of course we interpret the provisions on the basis that we presume Parliament to intend to comply with its treaty obligations.
Yes.
So I wonder if you could just at some point help me on this issue as to the extent to which we should be taking account of EU law.
Yes.
In the interpretation of these provisions.
So if one were to consider, for example, I haven't got time to turn it up, but the case of the House of Lords in Zielinski-Baker, which dealt with the scope of zero rating in the context of, in that case, I think it was a listed building, grade 2 listed building. what the House of Lords did was it recognised that zero rating was a derogation from the principle that VAT ought to be applied on economic activity. It therefore didn't apply an expansive construction of the zero rating provisions in question. It recognised that there was a potentially anomalous position between the domestic approach, in which a building which was an outbuilding used for changing rooms for a swimming pool was within the curtilage of a listed building and therefore formed part of the listed property, but wasn't used as a dwelling and therefore couldn't benefit from zero rating. So that's an example in which the constraints applied to zero rating as a matter of EU law operate to influence the construction that you give to the domestic legislation. And we say here, one could, and the appellants are seeking to, apply to the concept of disposal of the entire interest, all sorts of caveats, all sorts of factual permutations that may arise on a given set of facts that one would say, oh, well, that shows that they haven't disposed of their entire interest in the relevant zero-rated transaction. Where, however, here, the zero-rated transaction is the transfer of ownership, outright ownership of the property, absolute titles being conferred. It's very difficult to see in those circumstances why a subsequent transaction involving a different taxpayer should operate to limit that without, if I may say so, rewriting the very express words that Parliament chose to use. And the other EU law principle that is a constraining factor on the interpretation is the fact that zero rating is on a ratchet. And Parliament having chosen to limit the scope of zero rating in this way, it would respectfully be inconsistent, respectfully suggested it would be inconsistent with that statutory intention to give it a broad meaning, which undermines the limiting purpose of the words that we used. And as the upper tribunal found, and it hasn't been challenged, these measures operate in part as an anti-avoidance mechanism. So they are designed to avoid, if I may put it this way, jiggery-pokery by people and tax advisors in the construction sector, coming up with a series of factual permutations which are designed solely to achieve a situation in which there hasn't in fact been a disposal of the entire interest. Now, in circumstances where you've got rid of ownership and you are no longer master of your own destiny in the use to which the building is put, that is a simple and bright line test, consistent with a restrictive approach to the construction of VAT, which we suggest is to be preferred.
But although the provision on change of use is secondary to disposal of interest, it is always there as a backup, isn't it?
Yeah.
So if you get jiggery-pokery, then you could point to a change of use.
But it's much harder to point to a change of use when the person who is the taxpayer against whom they're the only person against whom you can impose a charge to tax, unless one designs in a completely different scheme, the one proposed by Lord Briggs yesterday, where he said, well, Parliament could simply impose a charge on the purchaser. Well, yes, of course, but that wouldn't then be in keeping with the scheme for VAT, which very much follows transaction-based approach, and therefore the person who has derived the benefit of zero rating here is the person acquiring the building.
But why is it difficult to prove change of use? I appreciate we're dependent on self-assessment, but that's the problem throughout that law, and you have ways of dealing with that and enforcing liabilities. But it must be pretty obvious if somebody's not using a building for the purpose for which it was acquired.
Well, that no doubt was the reason why when initially drawn, Parliament chose to only go so far as to change of use. But there must be a reason why they decided to then move from a solely change of use position to a position in which an outright disposal of the interest is also caught.
But it might be said that by using the word entire, which must be given a meaning, Parliament was only intending to catch a fairly limited range of situations and was allowing a great deal of activity to go on which might constitute disposal of something approximating to an entire interest, which would only be capable of being caught, if at all, by the change of use provisions.
Well, my lady, to the extent that what we're dealing with here is what was intended to be obtained was an adjustment. An adjustment to the recovery, effectively the de facto recovery of the input tax that's otherwise left hanging in the chain. That adjustment process under the capital goods scheme would require a disposal of the whole interest in the building to be treated as taking the capital item out of the capital goods scheme, and it would give rise to the charge to tax that I've identified, albeit through a different mechanism. Now here, if one sees Parliament as seeking to replicate that, then Parliament was simply making explicit that which was implicit, which was, if you dispose of the entire interest in the building, then that's not to be equiparated with ongoing use of the building for zero rating purposes.
But if the real issue is change of use and making an adjustment where you cease to be entitled to the zero rating, then a sale and leaseback may not be fall naturally within the policy of the provision.
As I've indicated, the 2008 provisions were premised simply on change of use. We wouldn't be here if we were simply dealing with 2008. We are dealing with Parliament's express use of words that capture this transaction. And the question is whether there's anything in EU law or elsewhere which means that one should give that clear wording a restrictive meaning, or an expansive meaning ultimately in terms of where it produces an outcome for the taxpayer.
And we could find that within the text of the Act or within EU law.
But one looks at the text of the Act and then construes it in the light of the fact that Parliament, having had its knuckles wrapped in the EU Commission infraction proceedings, chose to introduce a series of measures that gradually whittled down the scope of zero rating precisely in the commercial property sphere because of concerns that it was giving a too favourable treatment of VAT for commercial property. And they've identified here, it's telling, for example, that they haven't brought residential dwellings within the scope of this self-supply charge. Why? Because they clearly still fulfil the social function. What is in issue here is the concern that commercial property, of which the care home is an example, will end up being used and being available on the market for use as a commercial property rather than one that has a relevant residential purpose.
I must stop, but it would be difficult, would it not, for the Commission to say the UK has gone too far if it allows, if it ceases to require the adjustment for sale and leaseback, when in Maidabel, and I think in other situations, the Court of Justice has specifically permitted a substantive approach to look at the substance over form.
Well,
I mean, why should my Lord Briggs wants to ask a question, but I would appreciate at some point you deal with that.
yes.
I just feel I must ask this in fairness to you. Why is not this a possible purpose behind subparagraph 2? We all agree that subparagraph 3 is designed to satisfy Parliament's concern that zero rating should require a 10-year use of the building for the relevant purpose. Why does not the new subparagraph 2 requirement simply reflect Parliament's concern that a personal company which gets the benefit of zero rating should only do so and not have to give it back if it retains some skin in the game, namely the relevant use of the building for the requisite period? And that's reflected in a very low hurdle, must retain just some interest in the premises.
My Lord, they don't retain an interest in the premises when they've got rid of ownership. They are no longer in control of its use.
I quite accept it may not be the simple slam dunk answer to the question of construction, but I'm just looking to see if we can all agree about the basic objective, which is just that it shouldn't, that someone who's here today and gone tomorrow, so he gets his zero rating and then sells on and goes and does something completely different, doesn't get the long-term benefit of zero rating. He must maintain some elementary minimal skin in the game for 10 years.
But my Lord, I readily accept that the function of paragraphs 35 to 37 is to provide for an adjustment to the tax situation, putting it neutrally, in circumstances where the conditions for zero rating are no longer met. But Parliament has defined how those conditions are met, and it says if you've in fact got rid of the interest in the property that was the subject matter of the zero rating transaction in the first place, that's it. And as it happens, that's exactly the way that the capital goods scheme treats a sale and lease back under the capital goods scheme. It still comes out of the capital goods scheme, notwithstanding the lease back. So by introducing a different construction here, this court would be setting apart the treatment of the same item under the capital goods scheme from the treatment of a zero rated transaction under paragraphs 35 to 37. And I do say in context that can't have been what Parliament intended. I am running short of time, I'm afraid, and I need to give my Leonard Junior his duly delivered rugby ball with on attack. Can I just say on Sargison and Roberts very briefly, different statutory regime. It concerned capital allowances that were effectively accrued. The agricultural tenant had used the land in question and obtained the benefit of the capital allowance. The question was not about, is the condition for ongoing tax treatment maintained over a course of time? It was a case of who should get the benefit of the capital allowances that have already been adopted. And that's a very different analysis from the transaction-based approach and the need for adjustment over a 10-year period that we're dealing with the capital item here. Now, should it prove necessary to do so, I would respectfully also suggest that Justice McGarry reached the wrong conclusion, because of course in that case the trustees who obtained the freehold interest on a conferral of a trust with Mr. Roberts staying as settlor, nonetheless could have asserted the capital allowances themselves. So it seemed to me that that case was a question of who should get the money. Was it the settlor or the trustees? And Mr. Justice McGarry in those circumstances didn't think it was a particular stretch to say that it was fine for the settlor of the trust property to retain the interest of the capital allowance. Now, in terms of NEC and Bucket, I think you have my submissions from yesterday as to why it's not appropriate to use that analysis for a single composite transaction here. NEC built on the everything everywhere case law. What happened for a while in invoicing cases was that a taxpayer would try and hive off or split the supply or split the charge for a supply between a standard rated supply and an exempt supply. And attempts to do that have generally been resisted. EE for a while had on its mobile phone bills a separate payment service charge which was exempt compared to the taxable underlying supply of mobile communication services. The court resisted that in everything everywhere, and they then simply applied similar treatment to Bucket, even though there was a third party involved. The way of Bucket and NEC don't actually lead to a conclusion on the facts that that is an appropriate thing to do. But they simply suggested that that's something the National Court could have considered. And of course, the National Court might consider that in a tripartite contract with an intermediary, the proper transaction to consider is that between the principal and the customer, rather than between the agent and the customer. And that explains that. In terms of a single supply analysis, I do reiterate that, of course, Robert Gordon's college would necessarily have been decided very differently if that were the case. It would simply have been impossible to reach the conclusion that there wasn't a case for a self-supply in that case. I do then need to deal, I think, with Maidebel. Now, Maidebel involved consideration of two separate provisions of the Principal VAT Directive. One section was the rules that deal with adjustment, and if I can phrase that as a static analysis. So when one has an individual transaction, if, for example, there's a post-supply rebate, then that changes the consideration. That might then change the level of input tax recovery that's appropriate, might not. But essentially, if for a given transaction there is a subsequent change in events pursuant to Articles 184 and 185 of the Principal VAT Directive, then that can give rise to an adjustment. And that was one of the factors that needed to be considered. The other consideration was more of a dynamic issue concerning whether or not there was an adjustment needed for the purposes of the capital goods scheme, which of course we've been through with some care this morning. Now, in this particular case, what one had was the grant of something akin to a lease, but it was an emphyteutic right, emphyteusis over the property, and that gave rise then to a lease back, which effectively amounted to a form of providing a real property charge in relation to a loan. Now, the wording at paragraph 14 of the CJU's judgment, which is, I hope, at page 2083, that wording was inaccurate because it talked in terms of sale and leaseback. But in looking at the interest in question, they were a lease and leaseback. And in relation to that particular set of transactions, what the court in our respectful submission did at paragraph 41 at page 207 was to see whether or not there had been a supply of goods. So the court treated or questioned whether or not the grant of an emphyteutic right with a lease back amounted to a supply of goods. And it found that it didn't, because the supply in question did not empower the finance institutions to dispose of the buildings at issue as if they were the owners. And on that basis, there wasn't a supply of goods. Because there wasn't a supply of goods, there was no need to have an adjustment to the capital good, the land, the building, which was already in the capital goods scheme. There hadn't been any change in the use of that capital good. What there had been at most was a supply of services. If it's not a supply of goods, it must be a supply of services. Supply of services was not affecting the use of the capital item, therefore no adjustment necessary. Now, if the court were wrong on that, and looking at the niceties of domestic law, paragraphs 45 through to 48, if the referring court considered that contrary to that, there was in fact a supply of goods, which if the situation were in the UK, there would be a supply of goods, because the conferral of a leasehold right for 99 years would be a major interest in land. That's a supply of goods. So our domestic property law regime would treat it as a supply of goods. If that were the case, then an adjustment would be needed. Why would an adjustment be needed? Well, because the use of the capital item in the capital goods scheme would have changed. There would have been a disposal of ownership of that capital good, and in those circumstances, an adjustment would have been necessary under the capital goods scheme. Now, that therefore strongly suggests in our respectful submission that whereas here we're dealing with the transfer of outright ownership of an asset, an adjustment would be necessary for the purposes of the capital goods scheme, but it also means that the court's treatment of the transaction in question would not follow. So the court would not view a supply of goods with a further supply of goods back the other way from a different taxpayer as being a single transaction, which necessarily could simply be ignored or looked through for the purpose of working out what the input tax recovery should be. And the reason for that would be that there would be a substantial interference with the nature of use of the capital good that was part of the capital goods scheme by virtue of there being a separate supply of goods by the owner of those goods. My Lord, Lord Hodge.
When you look at paragraph 41 of Maidebel, it seems fairly clear that the court puts emphasis on the sale or the emphyteutic right and leaseback constituting a single transaction, and it isn't founding on a view that the emphyteutic right wasn't a supply of goods. It's asserting that you look at the sale and leaseback as a single transaction, and because of the leaseback, there isn't a supply of goods. And that seems to be the reasoning. And you seem to, in your presentation, you seem to be airbrushing out the single transaction element from the reasoning.
Well, my Lord, if one looks at 45, the court said the second question only arises if the sale and leaseback transactions at issue constitute a change in the factors used to determine the amount of deductions which were made after the VAT return was made, or a supply for the purposes of Article 188 of the Directive. So it's looking to see, has there been a supply, necessarily we say, of goods by this taxpayer to the financial institutions? Because they were treated as being a single transaction, they weren't therefore a supply of goods, and therefore there was no need for them to interfere with the initial deduction that had been given for the property in question. So what we can't do, we respectfully suggest, is simply say, well, that means that every sale and leaseback is a single transaction, regardless of the terms of VAT law and domestic property law. If a sale and leaseback properly construed is a supply of goods, and then a supply of goods from a different taxpayer, then you can't simply look through those transactions. You have to give effect to that supply of goods. And here, as you'll hear from Mr. Ross in the time I'm niggardly allowing him, here we have an outright disposition of ownership. Under VAT law, that is a supply of goods. Under VAT law, a lease of 30 years is a supply of goods. And so here we have, in contradistinction, not some form of financing transaction which the court is prepared to treat as a supply of services, but two distinct supplies of goods. And the reason why the court was leaving it for the national court was precisely to allow the vagaries of national property law to be taken into account. Now, what is wholly missing, I'm afraid, from the Maidebel judgment is what is the nature and characteristics of the single supply they identify. I mean, one could characterize it perhaps as some form of real property charge backing a loan, which would be a exempt financial supply of services to which no doubt the real property charge would be viewed as ancillary, with the result that you focus on an exempt supply of services moving from the financial transactions to Maidebel. And that may well be the way the court was thinking about it. But unfortunately, what we don't have in the judgment is any clarification as to how they would have gone on to treat what they describe as a single transaction and what its effect would be. What we do have, however, is the caveat in 45 to 48 of how they would have dealt with things if the proper classification was as a supply of goods. And that's where we say the relevant distinction is to be drawn. My Lord, there was also a point made on the social purpose behind zero rating, and it was said that our construction necessarily made things more expensive for residents of care homes. We respectfully disagree with that analysis. First and foremost, there is no suggestion here that the financing transaction could not have been achieved with proper thought by a different route. So the industry as a whole is not going to be saddled, if our construction is right, it's not going to be saddled with charges that have to be passed on to the residents of care homes. That's simply not the way it's going to happen. There's a different way of doing it, which this taxpayer didn't alight upon. The fact that this taxpayer didn't alight upon it is not going to doom the rest of the industry. More importantly, it's very difficult to see why necessarily any additional cost on a self-supply basis would be passed on. Most taxpayers, as Mr. Thomas recognised, would no doubt negotiate in advance for some mechanism of an option to tax or some other method to be adopted. So there was at least a recognition that the charge would have to be split between the relevant parties. And more fundamentally, we know from competition law analysis of pass-on that the extent to which any particular charge is ultimately borne by the final consumer is exceptionally difficult to ascertain. So with greatest respect, I think much care needs to be exercised with the acceptance of an assertion that the inevitable consequence of this is that charges to residential care home occupants will increase. In any event, even if that were right, you do not simply construe, with respect, these paragraphs 35 to 37 with a view to making it as cheap as possible for people who would otherwise have benefited either from an exempt supply or from zero rating. One needs to bear in mind the competing considerations of avoiding tax avoidance, keeping a proper limit on zero rating, and making sure that the benefit of zero rating isn't misused or leads to improper lack of adjustment. My lords, my lady, I've run out of time. Conscious that there's a break now, probably, and then Mr. Anderson will no doubt be pithy in his Scottish law analysis.
Mr. Beale, thank you very much. So, Lady Arden, do you
Very
want to...
swiftly, on the wording of our provisions, would the demolition and rebuilding of a care home constitute a single supply within the interpretation of that expression by the Court of Justice? You can answer it later, don't worry about it.
Could I take 5 minutes just to
discuss
with my clients?
Well, Mr. Beale, rather than you closing your submission, when we return from our short adjournment, you can answer Lady Arden's question at that point.
Thank you.
We will adjourn now, and Mr. Anderson, you've waited patiently. We'll return to you after the adjournment. We can resume now. Mr. Beale, I think you wish to answer Lady Arden's question.
Yes, my lady, the answer I think is to be found in page 1057, which deals with Group 8. Group 5 of Schedule 8 to the VAT Act, and a building only ceases to be an existing building when it's demolished completely to ground level. Now, if a building is completely demolished to ground level, but there is no transfer in any way of the land upon which it's based, then there hasn't been a disposal of the entire interest of the zero-rated interest that was acquired on an acquisition of both land and building. But a self-supply charge could arise, depending on the facts, given that if the consequence of the building being completely demolished is that it's no longer being used for a relevant residential purpose, then the self-supply charge would kick in on that basis.
Thank you.
Mr. Beale, thank you very much. Mr. Anderson.
My Lords and my Lady, it falls to me just to address certain of the Scottish law aspects of this, and I propose to do so in 4 very brief parts. And I'll look first at the disposition. I'll then have a quick look at the 2 House of Lords cases in Clydesdale Bank and Dollar Land. I'll then look at the lease and just say a couple of things, fourthly, about the appellant's arguments. So if I can ask the court to please turn up the disposition at 442 of the bundle. If the court has that, this is the BCL to target disposition. The court will see the capitalised terms dispone, to and in favour of target, and then there's the all in whole, and there's the description of the plot of ground which is disponed, which is coloured pink, which is defined as the disponed property, and that is then followed with the clause together with, and then there are 5 sub-clauses. I will not read them all out and move straight to clause 5, where there is the disponed property together with 5 our whole right, title and interest present and future therein and there too. And I'll come back to that in just a moment. This is a part and portion disposition, and if I can ask the court just to turn over to the 2nd page of it. One sees the capitalised terms with entry, and there follows and actual vacant possession at the 8th of March. We'll come back to that in a moment. And then one sees at the bottom the date of signing was the 7th of March. That was 1 day before this. Now, just dealing with each of those items very shortly, dealing first with the words whole right, title and interest. This is a standard formulation in a Scottish disposition, and in my submission it means what it says, whether one applies a technical or a non-technical approach to those words. And the key point here is that once P, here BCL, has disposed of its whole right, title and interest, so 100% of its ownership interest, there is no further interest for P to dispose of. So the focus of the attention on P has disposed of P's entire interest, then in my submission on the natural and ordinary meaning of the words of the disposition, it has. And insofar as the appellant submits paragraph 20 of its written case, which is page 38 of the bundle, that it's plain that BCL never disposed of its entire interest in the property, then at this first stage of the analysis, and we'll come to the lease in a moment, it is sufficient for me to say that, well, in terms of BCL's own deed, it did dispose of its whole right, title and interest. Dealing then with the actual vacant possession clause, given this is the BCL to target disposition, one must ask the question why, given that we know that there is to be a lease back. Well, this in my submission is tied to clause 4 of the missives. And if I could ask the court to turn to that at page 539 of the bundle. Bottom of that page, one has clause 4, which deals with the date of entry. And this is subject to the seller's right of occupation and possession of the properties. That includes the care home in this case, by the leases. The seller shall give the purchaser entry, purchaser here being target, entry to an actual vacant possession of the whole of the properties on the date of entry, and the giving of such possession being an essential condition permissive. Pausing there, in my submission, the reason for that particular provision in the context of the leaseback is to make it clear that BCL's possession after this transaction will be attributable entirely to the lease and not to any prior interest that it had. And that is, in my submission, consistent with the Robert Gordon's case. And I won't take the quote to it now, but it's page 1329 and the last line in the page. So before I go to, that's all I want to say about the disposition. It's a short document and the words are, in my submission, clear. Before going to the lease, what I propose to do is just go shortly to the two decisions of the House of Lords, one in Clydesdale Bank and the other in Dollar Land, just to give the underlying principles for why the transaction may have been structured as it was. Clydesdale Bank's at page 1333 of the bundle. And the facts of this case are perhaps mercifully a little simpler than in some of the VAT cases. There are three co-owners, parents and a son, who purported to grant a lease to the son. They had already granted security over the property. The bank seeks to enforce the security, and the purported tenant, the son, seeks to found upon his security of tenure as a tenant, when the bank seeks to repossess. And the House of Lords held there was no valid lease. Now, there are just two short propositions that we seek to take from this case, and the first is found at page 55B at 1337, which I doubt is controversial, which is that for one individual to grant a lease in favour of himself over his own property is therefore a legal impossibility. I think that's controversial. The second point is at 1338. Page 56E to F, which provides the commercial rationale for this, and I'll explain why this is of some importance in a moment. In the speech of Lord Hope, starting in the second place, this is just perhaps another way of viewing the same point. An action of removing at the end of the lease would not be effective to terminate his right to continue in occupation of property. His right of occupation being the son, who was on the one hand co-owner, but on the other hand was also seeking to exercise the rights of the tenant. The termination of his right to continue in occupation as the tenant of it would be pointless and ineffective, as he has the right to continue occupation of it as one of the proprietors. It would not be open to the court to grant an order for his removal from the property, which he was entitled to occupy as one of the pro-indiviso proprietors. The same reasoning would apply to an attempt by the other pro-indiviso proprietor. So, pausing here, my reason for mentioning this authority is that in order for the leaseback arrangement with a provider of finance to work, P must dispose of 100% of P's ownership interest. That is to say, P's entire interest, in order for the transaction to work. And the second short point is once P here, BCL, has done that, it is gone. Now, the second authority is Dollar Land, and I seek to refer to this, which is at page 1346 of the bundle. Really for the very short proposition that lease and leaseback in the context of the financing of heritable property in Scotland is entirely normal and is available. And that is evident from page 95E to F, that's 1351, again, of Lord Hope's speech. Where he points out that the structure involving a head lease followed by a sublease back, there's a 125-year head lease and a 99-year lease back, he says of the structure that was employed there, that the structure of the arrangements under which they were to be enabled to obtain that return on the investment was unremarkable. The mechanism which the Development Corporation, which was the owner, the CIN, which held the head lease, decided to employ when they entered into the 1979 agreement, which involved the interposition of the head lease and sublease between the interests of the owner and the occupiers of the shopping development, is one which is commonly found in commercial developments on this scale. Nor was it remarkable that the sublease contained an irritancy clause, clauses of this type commonplace. And I mention that because this was a case where the irritancy clause in the sublease was founded upon and was effective as a result of litigation to the House of Lords in 1992, albeit that there was catastrophic commercial consequence for the transaction. So that's the general background of what is available, and it's against that background that I propose to turn to the terms of the lease, which is at 459. The court, I think, has already seen certain parts of the lease, and this is the lease granted by Target as landlord to BCL as tenant. Don't propose to read out long provisions, but simply to draw attention to certain headline points. We know already that the rent that was due under this commercial lease was around £318,000 per year, and there are a large number of provisions requiring the landlord's consent to do all manner of things. And in relation to that, at page 466, one will see at clause 1.8 that those consent provisions extend not just to the consent of the landlord, but also to the heritable creditor of any premises. 467, there is the fundamental clause which involves the grant of the lease, and this is a lease by the landlord to the tenant, so it's by Target to BCL. The court sees some of this provision. Clause 3 is at 469, and clause 3 is, as a whole, contains the obligations incumbent on the tenant. And one has a very long provision setting out in the orthodox way the obligations that one would expect under a commercial lease, where the terms look rather as if they've been set by the landlord, including, for instance, at clause 3.4, which is at 472 of the bundle. The full maintenance, repairing, renewing, rebuilding and reinstatement obligation. So obligation to reinstate at the end of them. As well as the full panoply of obligations to obtain the landlord's consent in relation to, for example, in 3.9, 477, alterations, no alterations without consent. 479, one has the alienation provisions, again, unremarkable terms. 311 and 312, essentially, no securities and no alienation, no trusts. At 312.3, one has, although there's the prohibition on assignation, that's not without the prior written consent of the landlord. And one then has in 12.6 and 12.7 detailed provisions as to the limited class of parties to which consent may be allowed, assuming in terms of 312.4 that referees have been provided. When one turns over the page to pages 22 and 23 of the lease, one sees the detailed provisions for the types of assignees that would be permitted, involving all sorts of covenants and so on. Just a couple other provisions as headline points I would propose to refer to. 487 There is an indemnity provision by the tenant in favour of the landlord. 489. There is the annual capital expenditure clause, whereby the landlord can, by notice, require the tenant to carry out capital expenditure up to £20,000 per year, to be increased annually. And then it's moved to page 494. There is the irritancy clause, which includes 5.1.1 non-payment of the rent, the final provisions for which comply with the relevant statutory provisions are at the end, and also 5.1.4, the various insolvency events to which Mr. B previously referred. And two final provisions is 497. There is a provision dealing with value-added tax. The only point I'll simply highlight as a curiosity in this provision is the reference in the middle of that clause to Part 1 of Schedule 10 as in force at the 1st of June 2008. Not entirely clear why that date has been identified. Certainly, as we know, Part 2 of Schedule 10 was altered in 2011. And finally, just moving to page 502 of the lease, there are the final clauses where it's clear, as if it were not otherwise, that the applicable proper law of this lease is the law of Scotland, and there's consent to reservation for preservation and execution, essentially the tenant granting a decree against itself for any sums that come due. So I'm sorry for taking that in some haste, but my purpose for having done so is really threefold. The first is this, that it's from the perspective of Target, the landlord, it's only because of the disposition of ownership it's possible for Target to have granted the lease. If the purpose was security in relation to finance, then the disposition of the entire ownership interest was an essential step. The second point is that following this transaction, the appellant's possession was attributable entirely to the lease and not its previous ownership. This is the Robert Gordon's point, emphasised in the context of that self-supply charge. And thirdly, the lease does not contain redemption rights or a repurchase option. So at the end of the 30-year term, the expiry of the lease, BCL will no longer have its care home. So that's all I want to say about the lease arrangements, and the final couple of minutes I'll just address a couple of the arguments that have been made by the appellant, if I may.
Mr. Anderson, just before you do, can I just check, because I'm not familiar with this part of Scottish law, or indeed any other part to any great depth. Is there nonetheless scope for relief from forfeiture within the term? Relief from irritancy within the term?
Irritancy is regulated by two statutory provisions, the first of which was the subject of the decision of the House of Lords in the first of appeal in Dollar Land, which is essentially at the end of clause 5.1 of this lease, one requires to have given 14 days notice, and there's an opportunity to purge the monetary breach within 14 days.
That's enough for me, thank you.
And for non-monetary breaches, it must have been, I forget the precise statutory formulation, but it's a fair and reasonable formulation.
Thank you very much.
Turning then just to a couple of the appellant's arguments, and I will be brief. Page 51 of their written case. That's 51 in the bundle, 55, 54 to 55 of the paragraph numbers. It's suggested that there's no authority for the proposition that the rights enjoyed under the lease are a different source than those enjoyed as owner. Well, a short answer to that argument is The source is the terms of the documents to which BCL is itself a party. Paragraph 55, it is said that technical issues of property law, one of the constituent UK legal systems, ought not to be the foundation stone on which the interpretation of this provision is based. And three short responses to that. First, supplies of land are subject to express provision in the VAT Act, which in section 96 makes express provision for what amounts to major interest and a fee simple in England and Wales and in Scotland respectively. This, I may say, is also a distinguishing feature from Sargason. Secondly, the proper approach to the construction of contractual terms chosen by the parties is according to the proper law of those arrangements. And that's an orthodox principle of construction. So this case is concerned with supplies of land in Scotland, and the proper law of the lease is Scots law. So Scots law is really the only law that can apply, although I emphasise that for the avoidance of doubt, and as we have submitted, I don't understand there would be any difference in the English position where the documents were in the same terms. And thirdly, the nature of the rights enjoyed by BCL after this transaction follow from straightforward terms of the documents which BCL itself entered into. And it is, in my submission, pellucidly clear from the terms of the disposition that P did dispose of its entire ownership interests. And it's equally clear from the terms of the lease that any possession after this transaction is attributable to the lease and not to the ownership. My Lords, my Lady, I think given the time, I hope I may be forgiven if I don't go into some of the Scottish cases of the Latin maxims. Our short response to that is it's no different than nemo dat quod non habet, and there's no magic in any of that. I also hope I will be forgiven if I don't address in any detail the analysis of proper life rent. Suffice it for me to say that were the court minded to go down that particular route, there is primary legislation which my Lord Lodge in the chair I think will be familiar, because there was a House of Lords case dealing with successive life rents in 2002 in which he was counsel called the Earl of Bath. I think therefore the only final point that I have to make is that in terms of the conclusion of the appellant's argument, paragraph 65 at page 53, on the property law analysis, they say it may reasonably be concluded that private law analysis is that BCL, this is at paragraph 65, disposed of its right of ownership but simultaneously received back that part of its right of ownership consisting of the right of natural possession. And final sentence, BCL retained part of the interest it had in the care board immediately prior to the sale and leaseback transaction. Well, in my submission, with respect, that analysis does not follow, because it ignores the fundamental step in the sale and leaseback transaction, namely the second sale, without which Target would not and could not have granted the lease. These arrangements...
You're drawing a distinction between a disposition under reservation on the one hand and an outright disposition followed by a leaseback on the other.
Yes, although the short answer to questions of disposition by reservation, and the reason I suspect that the appellants have referred to proper life rents, is because leases are not generally granted by reservation. And it's difficult to see how a lease in these terms would ever be granted by reservation. And this is also what makes this case rather different from the sort of gratuitous settlements and leasebacks in Sargason or other cases. There was one argument mentioned yesterday, I don't know whether it will be pursued, in relation to the effect of the deemed variation of the term under English law. I won't address that other than to say that that doctrine does not exist in Scotland, and there is no problem with variations of the term in Scotland in terms of the statutory provision. I'll say no more about that. And so, in conclusion, therefore, rather than there being, as the appellants would have it, too shaky a foundation in the courts below, in my submission, the decision of the upper tribunal and the Court of Session is firmly grounded, both in terms of analysing the steps and the effect of those steps, and they proceed on the recognised substantive effect of a sale, disposition of ownership of land, and commercial lease respectively. That also has the benefit of straightforward application, as Lord John characterised. That, my Lord, already concludes my submissions, unless there's anything else I can say.
I see no questions being asked, Ms. Jansen. Thank you very much. Mr. Beale, do I take it that you've nothing to add at this stage of your submission?
My Lord, no. Thank you very much for the latitude allowed us on time.
Thank you very much. Mr. Thomas.
My Lord, my Lady, could I take you straight back to the explanatory memorandum which my learned friend Mr. Beale referred you to at page 1085 of the bundle? There's a little more that one needs to read in relation to that document than you were taken to yesterday. And it begins, if one has 1085, in a paragraph which starts just above those paragraphs to which my learned friend took you, which start paragraphs 35 to 37. Make provision for when and how a charge to VAT will arise in circumstances where the construction of or grant of an interest in a building has been zero rated. So one immediately sees that the intention of the legislation here is not simply to deal with the zero rated supply under item 1, but also to deal with supplies of construction services under items 2 and 4. And the reason for that is, and I'll explain this a little more in a minute, that one will not get the same supplies being made to the same person. The supplies of construction services, as one recollects under paragraph note 12 to group 5, has to be made to the person who is intending to use the building. So in the case where supplies of the grant is going to be transferred by way of the zero rating interest, that's going to be by the grantor who's not going to be using the building, but immediately to be making the transfer onto to the person who will be receiving the zero rated benefit. So items 2 to 4 apply at the construction stage, and and have nothing to do with what is thereafter going to happen. So one's looking at different transactions. In the normal sort of case, items 2 and 4 are going to be dealing with the case where a person who is going to use a charity, for example, who is going to use the building for relevant charitable purposes, engages a builder to build that building on its behalf when it already owns the property. So there will not be a disposal. Item 1, on the other hand, is the case where the developer builds the building and then transfers it on by way of a zero rated supply.
But when you demolish the entirety of a building, that would appear to be the disposal of premises, relevant premises. And I think, unless I got this wrong, the revenue accept that in that context, there isn't a disposition unless there's a change of use, which involves a rather modified version of meaning of disposal. Perhaps you.
Well, I agree with my lady. It does appear to me that in those circumstances, one has got to ask what on earth is meant by disposal. But it is fair to say that paragraph 36.2 talks about disposing of the interest in the premises rather than of disposing of the premises themselves. So perhaps that's the distinction to be drawn. So that was my first point. That and one sees that. Sorry, I didn't quite finish that paragraph. It goes on at the end of that particular paragraph that those provisions apply where that construction service or the grant of the interest has been zero rated on the basis of its intended use, a relevant purpose. And that use changes. Nothing about, and there is a disposal. It says, and that use changes, nothing more than that. And then down at the very foot of that first page 1085, one sees its description of paragraph 36.1. Paragraph 36.1, it says, provides for a charge to arise on each occasion that there is an increase in the use of the premises for a non-relevant purpose. And of course, as one recollects, paragraph 36.1 governs paragraphs 36.2 and 36.3. So again, the legislature is telling us that the whole of these provisions are directed towards use. The reason there was a change, as I understand it, between the 2008 regulations and the 2011 regulations was that under the 2008 regulation, specific provision was made for a case where there was a disposal to a third party, and that third party no longer used the premises for the same purpose. It wasn't dealing with a case such as we have here, where there is not a complete disposal and the continuation of the use by the same person as actually acquired the zero-rated benefit in the first place. So there was a very different slant to the legislation, in my respectful submission, from that which my learned friend gave you. So looking at that and trying to work out from that what the two respective sub-provisions are doing, in my respectful submission, the driver of paragraph 36.2 is that the legislature contemplated that where somebody disposed of each and every interest of any sort that it had had in the provinces or would thereafter have, so it no longer had an interest, there would inevitably be a change of use, or the use that would thereafter be made of the property would not be a use that the legislature was minded to consider. But in those other circumstances where the relevant person P continued to have some sort of interest at the end of the transaction, then one looked at paragraph 36.3 as regulating the way forward, with 36.2 being the backup if it ever needed it. So those are my submissions in relation to my learned friend's explanation of the explanatory memorandum. And looking at Fascali, my learned friend seemed to suggest yesterday there was some advantage to be gained from using Fascali as the company which carried out the construction, because this would mean that Fascali would get its VAT back since it was going to be making a zero-rated supply to PCL. Well, absolutely, that's right. Indeed, one sees there an example of the cases where items 2 and 4 do not apply, because Fascali was not going to be making use of the premises itself. And then he said, contrast that with the position of BCL, which as a person who makes partially exempt supplies would have been unable to recover input tax in full on the construction of services had it undertaken the construction of the care home itself. To which the answer is, well, no, that's defective as an analysis, because BCL would not have incurred irrecoverable input tax had it constructed the building for its own purposes, because such supplies as would be made to it would not have been standard rated, but would have been exempt under items 2 and 4 of Group 5. So that's the distinction, that the zero-rated items 2 and 4 engage where the person who is going to have the construction undertaken for it is actually going to be using the premises after they've been constructed. Now, there are certain restrictions in relating to architect services in items 2 and 4, but the commissioners themselves have always accepted, and in their manuals have mentioned this, that they're never a problem in practice, because what you do is you engage a builder who provides you with services under a design and build contract, at the end of which you end up with a complete building. And then the architect services get subsumed within the total composite supply of the design and build. And lo and behold, the relevant charity gets 100% of its the supplies made to it as being zero rated under those two items. So that's never been a problem. So there was nothing suspicious in what went on here, and the commissioners are incorrect to suggest that the interposition of Fascali facilitated 100% recovery. It was never necessary. It was just the outcome of the manner in which the transactions were undertaken. Now, moving on to paragraphs 33 to 37 of my learned friend's written case, which is page 73 onwards of the bundle. I'm going to pass lightly over quite a lot of this because you already have my submissions in opening. But as I understood my learned friend's argument in this area, he was seeking to suggest that there is a relevant chain of supplies here, because Part 2 of Schedule 10 operates by restricting the application of Group 5 of Schedule 8. It refers back to the zero-rated transaction and asks whether the conditions for zero rating are still satisfied. But with the greatest respect, that is not what those paragraphs do. The provisions leave the original zero rating provisions wholly undisturbed, and they impose their own non-technical, non-VAT conditions for the charge to arise under paragraph 37. And as I said yesterday, paragraph 37, contrary to the suggestion of the inner house, does not actually carry the deemed self-supply back to a date prior to the zero-rated transaction, so that then gets moved into that in order to try and adjust that. It creates an entirely new supply immediately before the relevant disposal or change of use takes place. So the provisions in Part 2 are potentially engaged if a zero-rated transaction has taken place, but that's it. After that, Group 5 of Schedule 8 and Part 2 of Schedule 10 go their own separate ways. Now I turn to my learned friend's arguments in relation to Midibel. His first basis of distinction was that there was a lease and lease back and not a sale and lease back. Or he suggested this morning that there was a grant of an emphyteutic right, which was akin to a lease but wasn't quite a lease, and not a sale and lease back transaction. Well, trying to scotch the emphyteutic right point first. If one looks at paragraphs 13 and 14 of the decision, which are at 2083, I think, the bundle. One sees that there was a grant of an emphyteutic right for a period of 99 years. And then out of that which was granted, the financial institution granted the use of the buildings at issue for a non-revocable period of 15 years. So the emphyteutic right had to be a lease of 99 years, because otherwise the financial institution, as my learned friend Mr. Ross Anderson has just suggested to you, couldn't have made that grant back of the lease because it wouldn't have had an interest in the property out of which that could have been granted. So just as my learned friend said yesterday that the supply of ownership was a supply of goods under paragraph 4 of Schedule 4, so I say that the grant of a 99-year emphyteutic lease would by itself be treated as a supply of goods under English law, and one assumes that a similar sort of position would be adopted under Belgian law. And the relevant provision is 1052, where one sees that the paragraph 4, the grant, assignment, or surrender of a major interest in land, so the grant of a lease for more than 20 years is a supply of goods. So the grant of an emphyteutic lease for 99 years is, one would say, a supply of goods by itself. So then turning, I think, next to my learned friend's arguments in relation to paragraphs 45 to 48 of Midibel, which are at page 2087. If one looks at those provisions, in paragraph 45, it is clear that the second question, says the court, arises only if the referring court, after verification, first considers whether or not they count as a change in the factors used, or it considers that they constitute a supply for the purposes of Article 188. Well, what are they testing there? They're not testing some other interest than the interest that Midibel granted to the financial institution. What's being tested there is what would the position be in relation to the sale and leaseback transactions at issue in the main proceedings here, if in fact the referring court decided it's not a single transaction but a number of separate transactions. And what's being said by the court in those circumstances is that grant of that emphyteutic lease would itself then fall within Article 185. So it makes no difference whether it's a sale and leaseback or a lease and leaseback. The rationale of the decision of the Court of Justice is it is the compressing of those two transactions into a composite transaction that leads to the conclusion that you don't in fact have a supply for the purposes of the capital goods scheme, and in my respectful submission, similarly should lead one to the conclusion that in the analogous position of the supervisory provisions under Part 2 of Schedule 10, there shouldn't be seen to be a disposal of the entire interest of the taxpayer either. if one then goes on to my learned friend's arguments in relation to NEC, I think I have to come back to Midabel later, but if one takes NEC next, my learned friend sought to persuade you the reason NEC was dictated by the failure of the domestic court to recognise that NEC was an agent acting for the promoter. Now, I say there's no evidence for that in the decision whatsoever, and if you go to page 2070, paragraph 7, halfway down the page, one sees the sentence I quoted yesterday, which is that the NEC does not at any time take ownership of the tickets as agents for the promoter. So the NEC, yes, acted as agent for the promoter, but in doing that, it was still the promoter that was making the supply of the tickets, which was a supply of services. And entirely separately from that, what had NEC entering into a contract with the customer, under which if the customer wanted to use finance transactions, its credit cards and so on, that processing service would be provided by the NEC itself. And the point is that one therefore necessarily has two separate parties. The NEC acting as the supplier to the customer of the processing service, and the promoter selling the tickets to the customer. And of course it's right to say that the customer wanted to buy the tickets and wouldn't have bought the processing services without the tickets. But that doesn't mean that there was a single supply of tickets from the promoter alone. There was a composite supply of two services from the combination of NEC and the promoter, and each of them had to account for the appropriate VAT on the element of the payment it received. One goes back to page 2067. In the head note, between letter F and letter G, you'll see how the case arose. In November 2002, the taxpayer claimed a VAT repayment on the basis it considered it overpaid the booking fees charged to the customers during the relevant period. That is to say, it overpaid VAT in relation to those booking fees. And the Revenue and Custom Commissions refused the claim on the basis those fees were charged by the taxpayer with consideration for supplies that were subject to VAT at standard rate. Now, if my learned friend was right that the only person who was making a supply here was the promoter, the commissioners should have repaid NEC in any event, because NEC would not then have been responsible for accounting for the VAT on the booking fees either. But they didn't do that, and they rightly didn't do that, because the effect of the composite supply analysis would have been to recharacterize the supplies as a single standard rated supplies, but it wouldn't be to recharacterize the persons who would be liable to account for the VAT in relation to those supplies. Each would have been liable to account for the VAT on his own particular part. So I say that these cases, Midabel and NEC, extend far beyond the abuse or origins in part service and Halifax, and operate whenever the conditions for a composite transaction are in fact engaged, however many parties may be involved. Moving to Robert Gordon's College. Robert Gordon's College is apologies, it's at tab 34, page 1323. And one notices at the top the date of Robert Gordon's College. It was heard on October the 3rd, 1995, and the decision was handed down on November the 16th, 1995. And what my learned friend said, well, of course, if Robert Gordon's College, if the single supply, composite supply rule had applied in Robert Gordon's College, they would never have come to the conclusion they did. The problem with that analysis is Robert Gordon's College is far too early. And looking at the history of the development of the single and composite supply rules, one starts in 1999 with Car Protection Plan, 4 years after Robert Gordon's College. And LeBob is 2006, Part Service is 2008, NEC is 2018, Midabel is 2020. None of those cases would have been engaged by Robert Gordon's College because the court was simply not taken to that sort of argument, because it didn't then exist. And if I could take you very briefly to what Lord Walker said in this sort of area in College of Estate Management on page 1570. He was dealing with the principles in the Card Protection Plan case, paragraph 28. He's actually addressing what Lord Hoffman had said in the Baynon case, of course, after his Robert Gordon's College case. He says, I concur in Lord Hoffman's speech in Baynon, and I have no wish to withdraw or qualify my agreement with any part of it, including his observations about discouraging citation of authority earlier than the decision of the Court of Justice in Card Protection Plan in 1999. And what Lord Hoffman had said is that the Court of Justice's decision at that stage was a restatement of principle, and everything started again, and we now knew where we were going forward, and therefore what had happened before gets lost in the mists of history. And one of the things that gets lost in the mist of history, I'm afraid, is Robert Gordon's College. It's too early. Which then takes me on to my learned friend's interpretation of part 2 of Schedule 10. So if I could then go back, I think, to apologies. It's at page 1064 onwards. My learned friend made much play about paragraph 35 and the definitions in paragraph 35 and the reference to the relevant premises, meaning the building or part of a building in relation to which a relevant zero rate supply had been made to P, from which he drew the conclusion incorrectly in my submission that meant that you weren't actually looking at the physical building. What you were looking at was some sort of construct from, and probably the interest in the building rather than the building itself. Well, with the greatest respect, that's not what it says. And when it says the relevant premises, it means the building, it means the building. The rest of that particular sentence simply defines the building with which we are concerned, which is it's got to be the building in relation to which a relevant zero rated supply has been made to be. And the reason for that is it's obvious in a case like this, where Pascali sold to BCL not only the care home, but also the cottages in the grounds of the care home, but zero rating was only available in relation to the care home. So we're focusing on the care home premises, but not on the cottages. And similarly, my learned friend suggests that when in paragraph 36.2, the legislation talks about P disposing of P's entire interest in the premises, that means the precise interest which P acquired by means of the relevant zero rated supply. There is no explanation or justification in my respectful submission for that argument at all. All that the question is being asked is whether or not P has no longer got any interest in the relevant premises after the transaction has been completed. And as I said in opening, it doesn't address in those circumstances how you deal with items 2 and 4, each of which is susceptible to a recapture charge under part 2, but neither of which will have occurred in the circumstances where there is then a first grant of a major interest in land to another party. They simply can't, because those supplies can only be made to the person who intends to use the premises in the first place. And I do take from paragraph 37 an important point, which is that when one is looking at 37.1, it doesn't take you back to the interest which was the subject of the original zero rated supply. It takes you to whatever the interest, right, or license in the premises was immediately before the relevant transaction. And if one was adopting my learned friend's argument, and one had therefore to have an item 1 20-year lease subject to zero rating, which necessarily is the subject of these rules, how on earth has P ended up with only a license at the time of the disposal? He can only have ended up with the license and nothing else if he's already disposed of every other interest, including the interest which he acquired by means of the zero rating supply in the first place. Now, if I can pick up a few other points from my learned friend's written case, which I didn't address in opening, one could start, I think, at page 81 of the bundle. Paragraph 48, where the commissioners rely on the purpose of legislation which was given by the Court of Session in paragraphs 27 to 31 of the opinion. I've already argued that, but all I would say about the parliamentary draftsman capping the benefit of zero rating is what my learned friend never made clear was why one would wish to remove the relief when the property was still being used as a care home, as the residential accommodation of the sick and the elderly. And if one tests that the other way around, in what circumstances would one want to remove the relief? There is a case to be made, an obvious case, for when the person who has enjoyed the benefit of the zero rated supply is no longer able to pass that benefit on to its clients because it no longer has an interest in the property with which it could do so, whatever that interest might be. And if one proceeds from that position, then the disposal of the recipient's entire interest in the premises and its cessation of use are two facets of the same concern. The concern is that the disposal occurs because the recipient no longer has any interest in the property, and then there's a significant risk the residents will no longer enjoy a reduction in their care home fees. And that's not a problem in the sale and leaseback case, whereas one sees here Balhousie continued to provide the same services and the same property to the same residents both before and after the sale and leaseback.
Mr. Thomas, is that point you've just made a variation of, or essentially the same as, the skin in the game concept which I put to Mr. B?
It is.
Which?
It's a similar one insofar as the skin in the game addresses this possibility also, which is that it has that P might have disposed of a sublease or an underlease, but have retained an overall controlling interest. That, I say, that skin in the game argument is much more difficult, although the commissioners have no trouble with it at all. So there is that subtle distinction between the two. And what I was going to say is, if the recipient were to retain the freehold and grant a very long lease to another person, the commissioners say, well, that's not a problem. 36.2 doesn't engage in those circumstances. We're perfectly happy to look at 36.3 as far as one can tell, even though he has already made his complaints about how very difficult it is for the commissioners to patrol and check that everything is being done properly. Is that not surely a much more difficult position where the lease to a third party thereafter uses the property is concerned than one where the grantor then has a lease granted back to it? And in paragraph 49, he says that the disposal of the entire interest in acquired property can rightly be equiparated with a change of use, since the purchaser is no longer in ultimate control of the use to which the building is put. And as I say respectfully, that makes no sense, save where the purchaser disposes of the entirety of the building and keeps nothing back, or disposes of so much of the interest as he has in the building that he really has no longer got any control. But those aren't our cases. There is no moment in our particular circumstances where BCL ever ceased to be in ultimate control of the use to which the building is put. It remains in occupation and possession throughout. And what is more, Target and its successors cannot prevent it doing so. And then there are a couple of other submissions in my learned friend's written case on Midabel that I haven't addressed, and he may not, in fact, have addressed you on either, but I'll sweep them up as it is. This is at page 84, one starts, in paragraph 58. But if we move on to paragraph 61 to begin with on page 86, I accept that there was no advocate's opinion here, but really, I think we know enough of the modern practices of the Court of Justice to know that it takes a fairly flexible view on whether or not it needs an advocate general, which is resource driven as well as driven by questions of whether or not there is new law to be made. Secondly, one has to take the decision of the Court of Justice as one finds it. One cannot seek to disregard clear statements of law laid down by the court merely because it was not previously appreciated. That's what the law was. And that, in my respectful submission, is what the respondents are trying to do. And in paragraph 59, my learned friend deals with this something akin to a lease, namely an emphyteutic right to use property. I think I've already made my points on that. It's a lease, whatever my learned friend may say, and it's a lease which entitles the lessee to grant subleases out of it back to the person who granted it to him in the first place. And my learned friend also says in that paragraph, at the very last but one sentence, the CJEU clearly considered paragraphs 28 and 40 that building would indeed continue to be used in the course of uninterrupted and permanent economic activity by the taxable trader for his taxable transactions. Pausing there, those were facts which were addressed to it by the referring court. But one asks, well, how would the referring court have known what Midabel was going to be doing in the future, unless it had accepted the evidence from Midabel of its subjective intentions in the future? So objectivity gives way in these circumstances, it would appear, to a degree of subjectivity as and when necessary. And here, the first-tier tribunal came to exactly the same conclusion, that BCL intended to carry on using these premises for the next 10 years as a care home. There is therefore no difference between this case and that case by reference to the intended future use of the premises. And those are my additional submissions made in reply to my learned friend, though I suspect my learned friend, Mr. Simpson, may have one or two things to say as well.
I don't detect any further questions for you, Mr. Thomas. Thank you very much. Mr. Simpson, do you wish to add something?
Yes, well, I'll oblige just a few minutes, if I may. I should like just to emphasize in the first place that what we are concerned with is an inquiry into facts and circumstances that relate to the tax treatment of the first transaction, that is to say, the zero-rated supply by Fiscalia to BCL. Those facts and circumstances may involve things that on their own count as supplies is not necessarily terribly relevant to that, because whether they constitute supplies is a legal analysis directed to a different purpose, namely the tax treatment of those transactions. Second point, this question of the difficulty of monitoring a lease on an ongoing basis.
Could I just pick you up on the first point?
Yes.
By that you are referring to the fact that it's an agreed fact that the disposition from BCL to Target was an exempt transfer. There was a supply of goods there, and similarly the transfer from Target to BCL of the lease, that again was an exempt supply. Is that right?
Yes. Yes.
But you say so be it, but that doesn't matter.
Yes, because we're analysing facts and circumstances for a different purpose, which is to do with the tax treatment of the first transaction. And
Yes.
that plays out over the 10-year period.
But I mean, that agreement that those transactions did involve supplies, it differs from the situation in Medibel, where I think the court was concluding that the sale and leaseback didn't give rise to a supply of goods.
Yes, well, that may well be the case, but in my submission, it's not necessarily.
But you say it doesn't matter.
It may not matter a huge deal. No.
Thank you.
Second point, this issue of the difficulty of monitoring a lease over time. My submission is that it's plain that the legislation has no problem with that, because all the difficulties identified by my friend Mr. Beale arise where the initial zero-rated supply is itself the grant of a lease. That would have to be monitored for the 10-year period for whether it's terminated and whether there are landlord and tenant disputes and so on. In that connection, the point my friend Mr. Beale made about being monitored, for example, for termination because of an event of default, namely insolvency, my submission is that such an event of default, insolvency, terminating a lease, would count as a disposal of an entire interest. And my submission that simply serves to underline that one has to take a broad and non-technical approach to interpreting this language, because if one has a disposal which is not involving any sort of grant or transfer or conveyance by the lessee, but is simply because of circumstances, even, for example, notice given by the landlord, then that suggests a very broad and loose meaning to be given to the term disposal. And in my submission, a similar approach should be taken to the remainder of 36(2) as a whole. And finally, was on the submissions on Scots law made by my learned friend, Mr. Anderson. If I may compliment him on those submissions. The only point I would make is that they do depend, as Lord and the Chair indicated, on there being a distinction that is relevant for paragraph 36(2) between a disposition under reservation of rights on the one hand, and on the other, a disposition that, in terms of the arrangements between the parties, must be immediately followed by a regrant or a grant of rights back to the disponer. I'm not sure if my friend Mr. Anderson would accept that it is at least possible in Scots law to reserve a lease right in the disposition of ownership. My submission is that certainly, at the very least, not clear. My submission is case law suggests it's possible, but in any event, the point remains that this inevitably comes to a need which my submission is not justified to interpret and apply paragraph 36(2) on the basis of fine distinctions of property and conveyancing law that just, in my submission, should not be relied upon in a context such as this, a UK taxing provision intended to operate in a practical way, in the same way across the 3 jurisdictions. And unless I have anything, unless your lordships have any relationship with any further questions from me, I would close my submissions and, with my friend Mr. Thomas, invite the court to allow this appeal.
Thank you. Thank you very much, Mr. Simpson. Well, I think that concludes submissions before us. It only remains for the court to thank counsel for their submissions, and also to thank those who have assisted counsel in the preparation and presentation of their respective cases. The court will take time to consider the issues which have been raised before us and will produce a judgment in due course. Thank you very much. The court is now adjourned.